Alrighty, so a long time ago, I did a copy of this video here, but I've had some more people subscribe, and I wanted to bring this up to your attention due to the corruptions of the courts. Okay, and it don't matter which courts you are entering, whether you're a U.S. national, sovereign citizen, or you going by legalese, all these things. It's the corruption that's involved. So when you go in there, there's more than one way to skin the courts. Instead of skinning the cat, you're skinning the courts. Okay? And everybody just seems to think that the courts are in fact honorable. And if you read the judicial canons, you'll find out how much they are not honorable and how much of the court has clean hands and disgusting reviews and how corrupt they really are. Number one, when you challenge jurisdiction in the court, and it don't matter when, they must tell you, and they never do it. Now, I've seen other videos that attorneys say, well, they just have it. They just have it. Well, Mr. Attorney, don't just say they just have it, because they don't have magic that just does not appear out of thin air. All right, and I'm not an attorney, not giving legal advice. Okay, this is educational purposes only, and we never look straight forward. We always look around us, be able to protect ourselves by any means necessary. So quit thinking inside the box and think outside the box. Be able to protect yourself. Okay, arm yourself with knowledge, and so there's going to probably be separate courts I'm recording, and it's going to be a bam, bam, bam. And that way you can see different outtakes of different courts that people are operating in and challenging the judges and jurisdiction and all that. And the one thing they have in common, they just seem to think they don't have to explain how they got jurisdiction, when it's just case after case after case saying that they do have to. So in fact, in law, in writing, by their own judges above them, saying they have to explain it. This is not complicated to some of you attorneys out there, and this is not complicated to some of you magistrate and judges. The higher ups told you this is what you got to do, and you got to answer it. And most of the time, a subject matter jurisdiction, okay, that they're liking of. And if they're in common law, MLT, or anything like that, they must clearly tell you so you can operate the courts in an honorable, clean hands way. Because if you don't know for sure what the judge is thinking, then what jurisdiction are you under? All right, let's go with this, y'all. As a man, in previous videos, we talked about man.
You get my notice?
Your notice, sir?
I'm not a sir. Can I have a seat?
Have a seat, please.
Did you get my notice?
Your motions that you filed, your notices that you filed, yes, the court has reviewed them. I'm calling court case 19 CM 1570. State of Wisconsin versus Ryan Robert Desmith. He is appearing in person without counsel. Assistant District Attorney Hannah Schuckert is appearing for the state. This is an initial appearance, and we're here today. Sir, have you received a copy of the criminal complaint?
I stand on my notice.
Did you receive a copy of the criminal complaint?
I stand on my notice. Sir, it'll be a lot easier if you just answer the questions. You got my notice.
Did you receive a copy of the criminal complaint, sir? This is a very simple question. I called other cases before you so that you could understand how the court process is proceeding. This is a very...
Now, just for clarification, again, I'm not an attorney. Do your own research, educational purposes only, right? He's saying, did I stand on my notice. Why? Because each and every time she asks a question and you answer, you're making some form of claim. And you're taking the burden of proof off the prosecutor or the plaintiff that's making any claims against you. Okay? And he's staying out of that area, so he's not coming in here making claims.
Simple question, you were sent a criminal complaint and a summons, and you are being charged with carrying a concealed weapon, party to a crime. That is a Class A misdemeanor. If you are convicted of that crime, you could be fined not more than $10,000 and imprisoned not more than 9 months. Count 2 is obstructing an officer, party to a crime. If you are convicted of that, that is a Class A misdemeanor. You could be fined up to $10,000 and imprisoned not more than 9 months. You are also being charged with disorderly conduct, party to a crime. That is a Class B misdemeanor. If you are convicted of that, you could be fined not more than $1,000 or imprisoned not more than 90 days. Now, knowing what you've been charged with and the maximum penalties, you have certain rights. One of those rights is for the state to prove these allegations against you in a court of law. You are also entitled to have a court trial or a jury trial. That is of your choice. You are also entitled to having an attorney represent you. If you are not working.
Now that's incorrect. Nowhere in the Constitution says you have a right to an attorney. It says you have a right to counsel. And the counsel is there to help you. Attorney is to speak on your behalf. Means you're too ignorant of the law to be able to take care of your own selves in court. Okay, so let's get this cleared up on that. Counsel is to kind of whisper in your ears and help you through the process through the courts, but you are going to speak to the courts, not counsel. You don't have a right to an attorney. Okay, counsel was before the bar union.
You can apply to the state public defender, and then an attorney can be appointed for you. If you do not qualify for the state public defender, you have several other options. One of those options is to defend yourself. Another option is to hire an attorney. If you call around and realize that you cannot make the retainer to hire an attorney, you can then come back to court and fill out a form for a court-appointed attorney. The county would then appoint you an attorney if you qualified, and then you would be responsible for paying back the county on a monthly basis for the attorney. Now, those are your rights, sir. This is the purpose of today's hearing. So, I need to know, do you plan on hiring an attorney?
I don't understand what you're saying. I don't speak your language, I only speak man to man.
Okay.
You got my notices?
Sir, those notices can be addressed upstairs in circuit court. At this point, I've told you the purposes of today's hearing. So, I'm going to enter not guilty pleas on your behalf.
If you enter a plea on my behalf, you will be held fully liable.
Now, sit and think about that. She's going to enter a plea. Okay? Why? Aren't we supposed to be in there presumed innocent? Right? Why is she making a plea for him? It's a presumption. We're presumed innocent. And why does he have to make any such claim? Guilty, no contest, or not guilty, when he's supposed to be in there presumed innocent. People, sit and think about this. This is the trickeries they're doing. They're trying to make him make a claim. And now what she's doing, speaking on his behalf like she is his attorney, and she's making a claim for him.
And you will have these cases, we will be then sending this case upstairs. This is going to branch 8 with Judge Lee Joyce. Now, before I enter that on your behalf, you do have a right to substitution. Do you have a problem with Judge Lee Joyce hearing your case?
Who are you?
I am the court commissioner. I'm in charge of hearing this introductory hearing in the court. I'm asking you, do you have a problem with Judge Lee Joyce hearing your case?
Who are you? You just answered the question, sir.
So we don't have.
If you hear the bailiff back there, just answer the questions. Just answer the questions. Just answer the questions. Remember, anything you say or do will be held against you in a court of law, people.
Time for this. I have a courtroom full of people.
I'm not a sir.
Mr. Ryan Desmith, I'm asking you a very simple question. Do you have a problem with Branch 8, Judge Lee Joyce hearing your case?
Whose court is this?
Would you like me to schedule, Commissioner?
Yes.
January 27th at 9 o'clock.
That will be your next hearing. It'll be upstairs in front of Judge Lee Joyce. The court has entered a not guilty plea on your behalf. And what is the state's request for bond?
State's recommending a $2,500 signature bond. Conditions to be no contact with the property. That is the Assembly of God Church. We're also asking for no possession of dangerous weapons.
Was there cash posted in this case? Let me check.
Whose court is this?
I don't see that cash was posted, Commissioner.
Court will issue a $2,500 signature bond. Also, no contact with, is this the Assembly of God
Correct.
Church?
Correct.
And also, no possession of any weapons. You can come forward, sir. Sign your bond.
I stand on my notice.
Sir, come on up. We don't have time for this.
I'm not a sir.
Either sign this or we're gonna remove it and refuse.
I do not service.
Okay, refuse and then you can leave. Okay, you're done here.
Goodbye.
Remember, y'all, right there, you do not have to sign nothing.
Jordan Thomas Salmi. This is 19 CM 1571, State of Wisconsin versus Jordan Thomas Salmi.
Have a seat, sir.
I'm not a sir.
Have a seat.
Let it be known this day, for I, man Jordan Salmi, am in a state of command, now passing forthwith. I'm not
Let me
responsible
take
for
him in.
I'm asking you to leave. Is that in order? Leave, please. Is that in order?
Excuse me? Is that in order?
Yes.
Sit.
Right there again, y'all. He forced their hand, right? He's asking, well, when they're asking you to leave, well, and you leave, you consented. Now, when he ordered it, then he must leave, right? It wasn't by consent. Anyway, don't know whatever become of him. I guess one of these days I need to look it up or whatever, but I haven't done it. But it's just an outlook on particular things you could do in court. Okay, not saying to do it, just saying educate yourself which direction is going to fit you the best. All right, till next time, Diesel We the People News. Bye, y'all.